One reason a court can set aside a relationship property agreement, whether it's a contracting out agreement or a separation agreement, is if giving effect to the agreement would cause serious injustice. Serious injustice can be evident at the time an agreement is signed. For example, an unfair distribution of assets may mean that an agreement is seriously unjust. This is part of the advice I give my clients at the time they sign the agreement. Even if some property is kept separate, the courts expect that a couple in a relationship does develop a pool of relationship property and that property is shared if they separate. If an agreement doesn't provide for the development of a pool of relationship property at all, then it is at risk of being set aside. For some people, it's a matter of circumstances changing over time, so an agreement that was acceptable has become seriously unjust. This is a potential issue with all contracting out agreements. People often seek to keep their pre-relationship property separate, but the longer the relationship continues, the less fair this may be. Particular issues arise when there's a disparity of income, so that over time one person develops a greater pool of separate property than the other. Issues also arise when there's a major change in circumstances in the household, such as illness, children, or purchasing real estate together. So contracting out agreements should be reviewed from time to time, just like a will, and if necessary, they need to be redone. Agreeable connects people who are wanting either a contracting out agreement or a separation agreement with lawyers like me who can advise them about the ins and outs of the particular agreement, including the risks of it being set aside by the court. Legal advice is necessary to ensure that somebody understands the effects of the agreement they are proposing to sign, as well as to protect against the risk of serious injustice. It is also a legal requirement for a binding agreement in New Zealand.